Welcome, welcome. My name is Daniel Canstrom, and as faculty director of the Rappaport Center for Law and Public Policy at Boston College Law School. And on behalf of our executive director, Lissy Medvedow, and our administrative assistant, Abby Chingo, here somewhere. Oh, there you are. It's my pleasure to welcome you to this important panel presentation entitled Protecting Children in Massachusetts. The protection of the rights and well-being of children has, of course, been a central concern in the U.S. for generations, for which many solutions have been attempted with what we could optimistically call varying degrees of success. It's also a powerfully complicated subject under international human rights law, I might say, which is my area. And in immigration law, it's a recurring theme that we talk about: families, children, various types of protection. So it's a set of extremely important issues. The problem, I think, has become ever more compelling in recent years. And I think many have felt a renewed and, to my mind, necessary sense of urgency about it. So I'm very pleased to see that we have an absolutely outstanding panel of experts with deep experience and deep and wide-ranging knowledge to help us understand the current state of affairs. My role is pretty simple. I'm going to introduce the moderator, but before I do that, I have a couple of points I just wanted to highlight. First of all, this is our last program of this semester. I know. Where are you going to get lunch? What's the problem?
The best is the last.
Yeah, we save the best of the last. If you have not attended any of our prior programs, let me assure you they were really terrific. And some of them are even recorded, I think, but you can make it up next semester when we're planning to kick off the spring with a program that's now tentatively entitled The Future of Sanctuary Cities, which will engage with state and local struggles over US and global migration. And we have several additional fabulous programs to follow. So please check our website early and often. I'm also very excited to report, and some of you know this, of course, but let me just announce it so everybody knows it, that Kimberly Atkins Storr, the Boston Globe columnist, will be joining us as the Rappaport Senior Fellow in February. She's absolutely amazing and will be a real treasure in our community. I'm very excited to have her join us. And students in particular will have lots of opportunity to engage with her and learn from her. It's really good for us, and I hope it'll be good for her. I think it'll be good for our community for sure. One other thing is that Tammy Mello, who was originally supposed to be on this panel, sends regrets she's unable to attend today's program due to a health issue. So she apologizes for that, and we apologize for that. This program is being recorded, and we're going to try our best to reserve at least 15 minutes for Q&A. And people who are viewing it on Zoom can use the Q&A function to pose questions. Also, I want to thank the Children's Law Group and the PILF Public Interest Law Foundation at BC who are co-sponsoring this event. So thanks to you all. And now let me introduce the Honorable Jay Blitzman, a living legend, if I may say so. A founder and first director of the Roxbury Youth Advocacy Project, a community-based interdisciplinary public defender unit that created the basis for the development of a statewide department. Judge Blitzman also co-founded Citizens for Juvenile Justice and still serves on the advisory committee. He's a founder of the Mass Bar Association Juvenile and Child Welfare Section and was the first recipient of the MBA Mass Bar Association's Juvenile Justice and Child Welfare Award. He co-founded Our RJ, a pre-arrangement restorative justice initiative, and he serves on the advisory committee of UTEC in Lowell, Massachusetts. He's also an Access to Justice Fellow for More Than Words in Metropolitan Boston, was a member of the BBA Steering Committee on the Cradle to Prison Pipeline, serves on the ABA Commission on Youth at Risk, and is the ABA advisor to the Criminalization of Student Discipline Committee of the Uniform Law Committee. So obviously a slacker, and I apologize for burdening you with that. Judge Blitzman teaches at Harvard Law, Northeastern Law School, BC Law School, chairs the Juvenile Committee of North.
Sign up for the Cradle to Prison Pipeline course. Registration starts tomorrow. On Friday, I'm sorry. Forgive me, I'm sorry.
Yeah, continue. And he's a faculty member of the Center for Law, Grade, and Behavior. We are delighted that Citizens for Juvenile Justice will be honoring Judge Blitzman at the CFJJ Leadership Celebration this December for, quote, his tireless efforts to achieve justice and equity for young people across the Commonwealth of Massachusetts. And I mean, I kid with him a lot. You can see he has something resembling a sense of humor. But I mean, it's really, it's hard to overstate the impact that this person has had on this field. So it's really a pleasure to turn it over to you all. Kidding aside. Thank you.
Thank you so much.
Welcome.
Wow, that was embarrassing. Part of my role shortly is going to be embarrass my fellow panelists in similar fashion. But before doing so, I just want to could you do this again? I want to give you a sense of the run of show. All right. Thank you very much. So the run of show. After I introduce the panelists, they're going to share some remarks concerning their backgrounds. Then I will pose questions to each, and then hopefully we will have time for some robust, some lively Q&A. Thank you so much, Jim. But before we begin, I want to make a few comments in a way to sort of frame the conversation. So, as Professor Canstrom indicated, the issues involving children are complicated and nuanced. I am sincere, by the way, in urging you to take the course that I mentioned, because we're talking about issues today which focus primarily on child protection. However, it's impossible to compartmentalize between issues that involve children in their homes, state intervention in the form of possible removal, whether in status offense cases or abuse and neglect cases. Given the fact that there's tremendous crossover between youth and the juvenile and criminal systems, we talk now, or advocates talk about the family regulatory system. And just to give you an idea of framing that issue, research shows a very high rate of crossover between youth who are involved in our system of child protection and the Department of Youth Services. So 2016 data showed that at least in that era, 72% of the youth who were involved in with the Department of Youth Services, our youth correctional agency, have been involved with the Department of Children and Family. And of that number, 55% had been involved with DCF below the age of 5, which means that they were allegedly abused or neglected. Most likely, given the data, the numbers came from allegations of neglect. So that's an important issue. And while those numbers now are not as stark, they're still much too high in terms of crossover. So this conversation will entail looking at a variety of issues. How to support children and family in their homes. Another piece of data that's interesting in this context is that the 2024 DCF budget currently allots approximately 90% of its dollars towards out-of-home placement, and only 10% of its budget to family support and stabilization. That's a significant public health question. So these issues are complicated. We hope to have a provocative conversation. We don't agree on all of these issues. Many of us have worked together for these many years. So what we hope for, and I know the Rappaport Center highlights provocative engagement, discussion, where we listen to each other and understand that reasonable people can reasonably disagree about many issues, but we really want to have an engaging, conversation. So, assisting me in that endeavor is the panel, and we do have a really all-star panel. So I want to begin in the order in which they will be sharing their comments. Maria Mossaides was appointed. Maria and I go way back. As the child advocate for the Commonwealth of Massachusetts in 2015, leading an independent agency that oversees children's services. For almost 40 years as an attorney and administrator, as an attorney and administrator, Maria has held a wide range of positions in both the public and independent sectors, including senior positions at the Office for Children, the Department of Social Services, the Office of the State Comptroller, the Supreme Judicial Court, and the Massachusetts Technologically Collaborative. Just prior to your joining us, Maria and I had a nice chat about her experiences at the Office for Children back in the day when I was a public defender. It was called the Mass Defenders Night, the precursor of a Committee for Public Counsel Services. And in that era, I could just go downstairs from the 6th floor of my office and go down to the 2nd floor and just try to arrange a cost sharing agreement, because many of our kids, as I've suggested, are involved in multiple systems and interact with agencies. Those days are long gone, although Maria will probably be sharing some of her work as the OCA and trying to bring back that model through the family resource centers. And I look forward to hearing more about that. Maria has also served as the executive director of Cambridge and Family Services, was the chair of the Children's League of Massachusetts in the public law section of the Massachusetts Bar Association. She was recognized as a top woman in the law in 2010 and received the Steadfast Award. I love that title, from the Francis Perkins Center in 2019. Maria is an adjunct professor in the public management program at Suffolk University. She holds an MPA from the Kennedy School at Harvard, a JD from SUNY at Buffalo Law School, and a BA summa cum laude from Mount Holyoke College. So give it up for Maria Mossaides. Jenny Chou, who was kind enough to share her run of show with me from her cell phone, because I forgot to bring the printout. My bad. Joined the Children's Law Center of Massachusetts as executive director in October of this year. Most recently, Jenny was the deputy director of South Coastal County's Legal Services. She was a senior attorney and a racial justice fellow at the Center for Law and Education, where her legal work focused on ensuring a quality education for public school students in Massachusetts, particularly those who are most affected by exclusionary policies and practices of various school districts. She also represented low-income, mostly court-involved students while at the Ed Law Project, and the Ed Law Project is really, really important. It relates to the so-called collateral consequences of young people who get involved in court, which include suspension, exclusion, and school continuity is incredibly important, because we know from the research that kids that don't graduate high school are much more likely to enter our systems, again, system of state intervention, DYS or the criminal system. Jenny has been in private practice, has served as a consulting attorney at the educational team at the Medical Law Partnership in Boston, was an associate at Stern, Shapiro, Weisberg, and Garin, and at the Criminal Defense Division of the New York Legal Aid Society. Her community-based legal services experiences including projects of the Harry Dow Memorial Legal Assistance Fund, and is based in the Asian Outreach Unit of Greater Boston Legal Services. Jenny is a proud graduate of Wellesley College and, as am I, Boston College Law School. Give it up for Jenny Chou. She also got a master's from Columbia and a bachelor's of arts from Augusta State University. Let's focus on the BC Law Committee. Okay? Santa Fadel. Pardon me? Okay. Yeah. It's okay. I need redirection, right? So Santa Fadel serves as the deputy director and is primarily responsible for CFJJ's legislative advocacy, and is the lead organizer of the Massachusetts Juvenile Justice Reform Coalition. And I want to tell you, as a person to participate in that, the email list is like of 150 people, right? I may be understating it. Prior to her work at CFJJ, Santa was the director of public policy at Rosie's Place, a sanctuary for poor and homeless women in Boston, where she led campaigns on access to substance abuse treatment, strengthening families, involved with the child welfare system, and improving services for customers applying for and receiving public benefits. She was responsible for advocating at the state level on issues affecting Rosie's Place guests, and empowering them through voter mobilization and advocacy. Senna holds a master's degree in public administration from Columbia University and a Bachelor of Fine Arts from Augusta State University. That was a mistake. My bad. He probably is going to be the first of several times. So we're now going to hear from our panelists in the order in which I introduced them, but final framing remark. You know, at this point in time, we hear the phrase inflection point. It's often used, but we are at a interesting juncture in so-called juvenile and child welfare justice. There was a recent, some of you may be aware of the tragic death of Harmony Montgomery. There's a Harmony Montgomery Commission is being created. There are proposals being made to rethink our child protection system, and some of these proposals even affect the way court cases may be heard in court. There's a lot of controversy, there's a lot of debate, a lot of which is related, I think, to some of the public health issues that I mentioned. We've had substantive criminal justice reform in Massachusetts in 2018, which included very robust changes to our juvenile law. We've raised the minimum age. Well, in 2013, we raised the maximum age of juvenile court jurisdiction to 17. We may raise it, hopefully, in the coming years, phasing it in, as has the state of Vermont, to 21 over a period of time. We've raised the minimum age of juvenile court jurisdiction. We know a lot more than we used to know, but we're still dealing in the context of a system which has searing racial and ethnic disparities. So there's a lot of work to be done, and hopefully so these panelists are engaged in that work. So I'm going to turn it over to you, Maria, for your remarks.
Good morning. I want to spend a few minutes talking about the Office of the Child Advocate and what we do, and then really sharing with you some of our current work that addresses the issues that Judge Blitzman raised. As he mentioned, the OCA is an independent executive branch agency. We were created in 2008 with the mandate to oversee all state-level services to children. We like to think that we protect the interests and rights of children and families, both on an individual basis and also in encouraging and making system-wide change. Our individual work really is composed of an ombudsman function. And so we operate a complaint line in which family members, community members call and raise issues about the failure of delivering services to children, oftentimes from parents who lost custody of children, that the children are not being returned home, and that we probably get 500 cases a year, of which every single case is thoroughly reviewed. We have access to all of the databases in the Commonwealth. And we intervene, I would say, in a little bit more than half of the cases where we agree with the complainant. We have liaisons with every single executive branch agency. And so we are dealing with people at the very highest level in terms of helping to address whatever the issues are that we identify. We also statutorily monitor programs, placements, and departments. We receive notices called critical incident reports of the death of every child, near fatalities, serious emotional injury, and a whole bunch of other information that comes to us, most of which is arriving on a daily basis, but certainly no less than weekly or monthly. We take that information and turn them into recommendations around actions that need to be taken to either improve the statutes themselves or more frequently policy and practice at the state agencies. I think we take great pride in that our recommendations are evidence-based. We spend a lot of time at the OCA working on producing data and working with our state agency colleagues to encourage them to actually produce and share information. I think that from my now 46 years in public service, the one thing my mentor said is we should not be arguing over the numbers. We should be arguing over the implications of those numbers. And I think that's really one of the sort of mantras that we carry along at the OCA. Our enabling legislation requires us to prioritize children in the custody of the Commonwealth. And that means children in the custody of the Department of Youth Services and children in the custodies of the Department of Children and Family. We do this work in a society in which there is structural racism. There has been structural racism even before the Declaration of Independence. And so the work that we do is impacted by, particularly in juvenile justice and child welfare, but also in the areas of health equity, of tremendous disproportionality. And I know that a lot of our work is not going to reach the point where we're going to be able to address the root causes of racism and inequity in this country. So we take that as a given, and we attempt to do the best that we can. We also focus on other marginalized populations, and that's LGBTQ youth, youth with disabilities, and a lot of our current activity is being spent with newcomers to the United States, individuals who have experienced a different form of trauma and who have language barriers that also will make it difficult for them to receive services. I can share information around the sort of the disproportionality. Certainly in juvenile justice, and this is fiscal year 23 data, more than a third of the youth held at pretrial were Black, even though they represent only 10% of the population, and 44% of detained youth were Latino, even though they only represent 18% of the youth population. In 2018, in the Juvenile Justice Reform Bill, the OCA was charged with the creation of the Juvenile Justice Policy and Data Board, in which we actually monitor the implementation of the improvements to the system. What we have done on the juvenile justice side is really focus on creating diversion initiatives. And so for the last 3 years, now operating in 7 counties, we have diversion projects that are designed, that are complementary to the changes in the law that allow a much wider range of individuals to divert other than the district attorney. It can be the clerk, it can be the judge. So what we're trying to do is to divert youth before they get to the court process. And the first year results of that work, because we heavily evaluate with external evaluators every project that we operate, looks very favorable in terms of the result. And we hope that as a result of a few more years of data that we will be able to convince the legislature to adopt this process statewide. I want to talk a little bit, moving from there, I think to, we've also, let me add one more thing. I've also drafted and filed some major legislation around changes in the truancy law. Again, anticipating that we don't want what we now call child requiring assistance cases, which are the old truancy cases. We don't want them to come to court at all. And we want them to be dealt with in a way that evaluates what the children and their family may need and have those delivered from our family resource centers in a whole redesign of the family resource centers. I want to talk a little bit about child protective services. I think all of us who work in this field recognize that the removal of a child from their parent is one of the absolute more serious exercises of the state's police powers, other than putting someone to death. And that's how I view this personally. I recognize the trauma to the parents and the trauma to the parents when we do this. And what we know is that there's disproportionality in Massachusetts, both in terms of the individuals who come to the attention and removed on the basis of both Black children, and Hispanic Latino children. The numbers for Asian children in Massachusetts and Indigenous children is very small. And so there isn't really disproportionality with respect to those two categories. But what I will say is that, and there's a lot of misinformation around what happens in child welfare in Massachusetts. I think a lot of that comes from an inappropriate comparison with national data. And if you look at the national data, the national federal government that collects data warns people not to compare data from one state to another, but to compare data with 1 year to another in the individual state data. However, we are running 50 states and the District of Columbia, 51 very different child welfare systems with very different legal standards. But what I want to share with you is some of the information that I think is going to be relevant to this conversation. In Massachusetts, we have a differential response system, and that is that of the cases that are screened in, 42% of the cases that come in are unsubstantiated, which means there is no finding of abuse and neglect. 17.2% represent cases of substantiation, which means that a child that DCF has requested that a child come into the state's custody. And an additional 40.8% represent cases that are cases of substantiated concern, which is services should be offered to the families, but the situation and the risk is not high enough that the child needs to be taken into custody. I want to share some data around the categories of abuse and neglect. 86.7% in the last reported fiscal year, which is fiscal year 22. The current fiscal year report should be out by December. So I'm giving you data that's now almost 2 years old. 86.7% represented neglect, 7.8% represented physical abuse, 3.5% represented substance-exposed newborns, and 3.5% represented cases of sexual abuse. I think one of the biggest challenges in child welfare is that we do not have a clear understanding of the risks associated with neglect cases. 85% of the neglect cases involve substance use disorder on the part of parents. And so one of the critical issues that I have been arguing for, and I'm hoping we will finally get it done this year, is for there to be subcategories in neglect, so that you can then, we will have data in structured data where we will be able to demonstrate the various categories of neglect and be able to more carefully present information. And that's not happening yet. What I can say, which I'm really excited about, is the Department of Public Health, the Department of Children and Families, and the Office of the Child Advocate are now engaged in a 2-year project to redesign how DCF responds to families who are involved in substance use disorder cases. And we expect that at the end of this 2-year period of time, that there will be a better understanding of assessing the risk of these cases, but in addition to that, assessing the kinds of services that need to be delivered. What I will say that over the last several years, the OCA has, in conjunction with the Department of Children and Families, totally redesigned their oversight of educational programs, ensuring that children who are in the custody of the Commonwealth receive the educational benefits that they need. A great many of these children require individual education plans because they have fallen behind in their sort of school achievement. We have also totally working with DCF revise the policies with respect to parents as well as children with disabilities in the Commonwealth, and we continue to implement, to monitor the implementation of those policies. We are currently working on 2 major projects. One is we've designed, and it's about to launch, a review of the children who overlap between DCF and DYS by taking a review of the qualitative data of DCF and DYS jointly involved youth to figure out whether there's anything that we can do to make sure that they don't cross those lines. We are also, you need to go on. So anyway, those are some of the projects that we are working on in an effort of reducing disproportionality, but also really trying to be focused on delivering the kinds of services that support the children and families. Thank you. Sorry, I went over.
Thank you. We could talk about these issues, you know, all day, obviously. Jenny.
Maybe I'll be a little briefer. So I'm a new executive director. The agency that I work for now is called the Children's Law Center. Our mission really is, and we're coming at this from a direct service individual child representation perspective. Our mission really is to promote the life outcomes for low-income children through legal representation in the areas of education, immigration, child welfare, juvenile justice, and associated areas, including insurance, access, and family law, et cetera. So we are a civil legal services entity. We go about this through individual representation that then allows us to focus on systemic issues around education and child welfare. Our child welfare attorneys are part of the Mass Child Welfare Coalition. And we really try to look at the practice that we have and how we can improve the individual representation. We are one of the only legal services entities in the state that actually focuses on representing the child, which can be tricky when we talk about child welfare and education in particular, where the family is often included. So we are very clear about who we represent, but it is in the context of the family unit often. Like I said, I'm relatively new to the director position in this agency, but I think we'll get into this, but obviously the crossover between all of the substantive areas that we represent children in, one case is never one case. It is an immigration case has an education component. It could end up in the juvenile justice system. So our attorneys generally end up understanding the practice of the entire range. I think we're going to get into the discussion, hopefully around what all of this looks like in practice, which is a very important piece of this, because we have data. We have, how do we bring this together with people who are on the ground, actually focusing on the day-to-day individual situations that all of these issues bring to bear when we talk about who is most impacted, who are the people in this system, what are the systems, I guess, actually doing to help individual families actually advance. And I think, we might have that as a common goal, that the systems are meant to actually help. And I think when we step back and think about how this happens and what services can actually be in place, maybe there's room to think about how we can all maybe do this in a better way. So the perspective that I think my agency would bring to this conversation is much more around the individual look and how that is impacted when we're talking sometimes at a much higher level of systems.
So just before hearing from Sen, I just want to say quickly, in preparing for this session, Jenny and I had an interesting conversation. Protecting children from who or from whom? From abuse or neglect. In some instances, in many instances, I would submit in the state intervention itself, given the quality of care in our foster care system, in our substitute care, these are difficult issues, and that's why I think that thinking about public health as a framing device is very, very useful. Senator?
Thank you, Jay, because that was actually how I was going to start. What is child protection? Because that's the theme of today. Like when we say protecting a child, what we want to propose to all of you is thinking about it in not just one linear way. We're going to keep a child safe. What does that mean? A lot of times in the media or just in just regular conversation, it means let's protect them for the child. A child got injured. Why were they in their own families and with their own family? We want to propose looking at the child as a whole. And when we look at a child, are we helping the child transition into adulthood? Have a healthy transition into adulthood. That's the language you use in the juvenile justice system. We want to make sure that our child welfare system also looks at that language, looking is the intervention helping the child grow up and be healthy into their adulthood. So I'll start first about the child protection system as we have it. I will distinguish when it's Massachusetts and when it's national data that I talk about. So in Massachusetts, the vast majority of cases under either abuse of neglect or under the neglect statute. As Maria mentioned, we have a vague, I believe that's what I mentioned, referencing our statute is not very clear about what it does not delineate what neglect is. So the definition is pretty broad and can encompass lack of resources or poverty, and often conflate with poverty. And this is not just unique to Massachusetts. 50 states' definitions of neglect, the vast majority of them can conflate poverty with neglect. We did there's a survey out during COVID to figure out what's happening with families and who's getting called around child protective services. And the narratives we heard were, someone called a child protective agency on me. They came in, they checked my cupboards, they checked that my house was clean. That was the investigation. So a lot of it is the child being provided the material services. As Jay mentioned, I used to do work on anti-poverty. And when I did advocacy on anti-poverty work, there was a lot of pushback. We don't trust these people. If they are getting public benefits, then they must be on drugs. If they're getting public benefits, then they don't want to work. There's all the narratives that came in from the 80s around welfare queens and so forth still permeates and was part of the debates when I was doing this work. When we know that this is actually a quote from a woman now who was in the child welfare system herself as a child. He said the state pay more in taking kids out and paying strangers to take care of them than supporting the family to get back on their feet. So what does that mean in terms of policy? So I just gave you the fighting we do, I know one of the things, there's campaigns right now to increase cash assistance or lifting kids out of poverty. That stuff is still happening. However, on the flip side, if that family is involved in the child welfare system, the typical service is you have an action plan. The action plan is what you have to do. It's a checklist you have to do so that you either your kid doesn't get removed or you get your kid back. A lot of times the supports to get that doesn't come in. So that's from the perspective of a family. I'm being very, very broad right now, just in the context. But when we look at the flip side of what the services that the child welfare agency offers, and Jay mentioned this, when we look at the number of children with open child welfare cases, about 87% of them are either at home or have a plan to reunify with their family. When we look at the child welfare budget, only 10% of that funds goes towards supporting those kids to remain home or to be reunified. We also have federal funds. So if you're familiar with the temporary assistance for needy families, that's the child welfare federal grant. It is a block grant that states can either use to provide direct cash assistance. So this is what the lift kids out of poverty, give families just direct cash and to help them out. Or states can use those for other services that allow them that would serve families that would have otherwise been eligible. so state agencies can use those $10 for anti-poverty dollars for their programming if the target population would be families in poverty. Some of those funds go to, some of those funds go towards DCF. 100% of them are for out-of-home placement. Not a single dollar of those federal funds under that block grant goes for the non-cap direct cash assistance goes to help these families. So everybody here talked about the overlap with the juvenile justice system. So CFJJ a few years ago worked with the Department of Youth Services and Department of Children and Families and asked, what is the overlap? So when you look, most children in the child welfare system do not end up in our legal system, but the vast majority of kids in our legal system are either current or previous child welfare history. And we worked with these agencies. They gave us the data, line level data. It was so we can see child one, all the data points at the child welfare and the DYS decision points, but without identifying information. And we found overwhelmingly that there were 4 risk factors. First one is having a 51A early on in our life. Jay mentioned
51A is an allegation of neglect in Massachusetts case law.
Thank you. So this is when you get someone calls in that this family's so a significant number of them were under the age of 5, under the age of 6. So the second risk factor was removal. So DCF at any point has a chance, has a decision. Can we keep the kids safe at home and provide services and oversight, or does the child have to be removed from the home? That removal increases the risk factor. There's also national research that links that removal. There's a separate study. It was actually an economist out of MIT looked at another state's data just because they have better data and tracked kids longitudinally. What happens to these kids and a cohort of kids over their lifetime from childhood up until adulthood. And they looked at juvenile justice involvement, criminal justice involvement, juvenile justice involvement, and public health data, birth data. And they said they looked at only placement. They didn't look at services. They didn't look at where type of placement or anything. And they excluded the extreme cases. So the vast, because there was no question the child had to be moved. They said, okay, let's look at the bulk of them where there is that, there is a judgment call about removal or not. And they tracked them over the length of time, and what they found that the kids who were removed from the home had a higher likelihood of juvenile justice involvement, higher likelihood of teen birth, higher likelihood of adult criminal justice involvement, and lower employment and early and quarterly income earnings. So we saw similar things that early on here in Massachusetts with that removal. As I go deeper, the third risk factor, which was one of the hardest, is placement instability. So Massachusetts, for the longest time, continues to be having lower performance by federal standards of how stable a child is when they're removed from the home. So by federal standards, a child, if they're removed from the home, once they hit their third placement, it is considered a failure by federal standards. That is the average for Massachusetts. And when you look at it by racial disparity, by race, the kids, black kids, Latino kids, and I want to say indigenous kids also have much higher rates of the instability. But when you look, and this is just for kids involved in DCF, when we looked at the kids who were involved in the juvenile justice system, that was not where they were. We were looking at kids who had 6 placements, 10 placements. There's in the cohort of kids we looked at, a young person by the time they were 17 years old were in 41 placements during their lifetime. And then the last risk factor is where they're placed, where we have them in congregate care settings or group home settings. But that was another risk factor of juvenile justice involvement. So
1 minute. Okay.
I have 1 minute left. Okay, all right. So just to talk about the disparities, I'm just going to put it out there because one of the questions when we do talk about disparities, is it that Black and Latino families are more abusive, or are Black and Latino kids more likely to engage in criminal behavior, or is it the difference in treatment? I will say the research says no. Okay, so I'm just gonna put that out there because that's always a theory that's looked into. But the system's responses are different. So when we look at who gets investigated over the lifetime of a child, if you are a Black child, 71% of Black children in Massachusetts will be subject of an investigation during their lifetime before they turn 18. When we look at Latino kids, we have some of the highest rates of having Latino kids subject of investigation and removals. And those disparities also mirrored in our juvenile justice system, where and then for Indigenous children, we have the Indian Child Welfare Act, right? Like we're protecting kids Indigenous kids as much as possible if they're removed, they're within their tribes. 13% of Indigenous children in Massachusetts have been removed, which is one of the highest rates in this country. So just want to end that we can look at the history of our child welfare system.
Well, that ending is actually the perfect segue towards the first question, which I'm going to pose to Maria. And Maria asked that this question be asked. So just to sort of frame this, part of the conversation, as it's come up repeatedly now with the comments that Senna made as well. One of the reasons that many advocates are now talking about the child welfare system as the family regulatory system, or perhaps the family policing system, notably Dorothy Roberts wrote Torn Apart. Oh, okay. No wonder. Okay. Dorothy Roberts, who wrote Torn Apart, which is a book I recommend to all of you, and it's a core part of my course. Whether certain communities are surveilled in different kinds of ways, whether there are analogies between over-policing and our child protection system that parallels what we see with stop and frisk, for example, of young Black and brown youth in urban communities. It's part of the conversation. And in 2016, Jill Lepore wrote this really, really important article called Baby Doe, A History of Political Tragedy, in which Maria was quoted. This was in the aftermath of the death of another child, baby Bella Bond, who was found abandoned on Deer Island. And what happens, unfortunately, as Lepore writes in that article, is that tragic cases often have tragic results. The pendulum swings, and we become really, really zealous, understandably, about risk assessment and in the name of protecting children. Factored into that tableau or landscape is the issues we're talking about. Most of the cases we see in our juvenile courts are allegations of neglect, as opposed to inflicted abuse. I think over almost 3/4 of the kids in placement in Massachusetts are there because of allegations of neglect. And Maria spoke very thoughtfully about how perhaps neglect has got to be more layered. But interestingly, in that art, and in terms of the crossover population, some of the data I cited came from that Baby Doe article. 55% of the kids involved with DYS have been involved with DCF. Of that number, we saw racial and ethnic disparities which parallel or exceeded what we see in our juvenile justice system, contributing to what Lepore characterizes as a birth to prison pipeline. So these are some of the issues. And now the tragic death of Harmony Montgomery and the creation of the Harmony Montgomery Commission, one of the issues is raised, is the pendulum going to move again towards more reporting, and will this adversely affect poor communities? Lepore writes in Baby Doe about the national historical response to tragedy has been a war on poverty, and the systemic response is to remove poor babies from poor families, as opposed to supporting families and looking for a different alternative to avoid state intervention. So Maria, to her credit, asked this provocative question. Should the child protection system and mandatory reporting be abolished, or can it be reformed? I think it's a really, really timely and very, very important question. Maria.
And let me see if I can try to address these quickly. One thing we need to understand is the statute in Massachusetts around the reporting of abuse and neglect represents I don't know whether I can call it the highest or lowest standard in the country. So we have the standard that requires mandatory reporters to report more than all of the other 50 jurisdictions. So that is the framework in which mandatory reporters file allegations of abuse and neglect. I think that I will not insult you by sharing with you the multitude of cases that I review on a daily basis and the critical incident reports that I get. I can assure you that the cases that come to our attention are cases in which there is real risk to children if they remain in their current situation. What I know, we don't have good data on this, but 75% of the cases go uncontested when they get to court for the 72-hour hearing. So that either says we're doing a lot of bad lawyering, or there is a validity to the allegations, which is not to say that I am blaming the families. I think that what we see a lot in the cases that the OCA reviews is multi-generational trauma. So individuals who themselves were taken into care, and that the likelihood is that their parents were also in care. That was the situation in the Harmony. That's practically the situation in virtually every one of the publicly released cases that the OCA has produced, represents multi-generational experience with DCF. And I don't want to minimize, because for me, this is really an important issue. When I started in this field 46 years ago, we did not understand the impact of trauma. I think back to some of the decisions that I made, and I think what I've made those same decisions today. So what we are dealing with respect to a lot of the youth who come into care and why there is the bouncing around, really has to do with the challenges faced by people who come to the attention. There is one sort of myth that I want to correct, and that is that with the data work group that I co-chaired with the Commissioner of the Department of Children and Families, we took a look at the sort of disproportionality at various decision-making points in the care and protection process. We didn't know what to expect, and I was like bracing myself for really bad news. What we discovered was the greatest disproportionality is at the part of the 51A reports, when people file reports. 85% of the reports in Massachusetts are filed by teachers, followed closely by EMTs and police when they respond to 911 calls, and then lastly, pediatricians in the emergency departments of hospitals. So one of the things that we have done is, and launched last August, is a massive retraining of every teacher in Massachusetts so that they are not filing useless 51As, right? Really, we all need to address our own biases. And so part of that training is really asking teachers to better define what constitutes a risk. And in conjunction with that, we're redesigning the family resource centers, which need to be rebid next year, in an effort of asking teachers if they have concerns about family with respect to poverty, if that's what you're concerned. Children are coming to school hungry or not properly clothed. Don't file with DCF, which is what they're currently doing, because they don't know what else to do. Send them to a family resource center, which will provide them with the financial support. There is one thing I want to say, and this is one that I would love to have the answer to. I do not believe, from the cases that we've reviewed, and I've reviewed thousands of cases over the last 8 years, that children are taken into custody on the basis of poverty. I believe that poverty plus something else is the reason why a child is taken into custody. And the stress that people have when they're poor results in oftentimes in substance use disorder. So that it's never poverty alone, it's never poverty alone, it's something perhaps brought about by poverty. I have asked the legal services people to bring to my attention any case that they have, including most of the advocates, where they believe that it was poverty alone that brought a child to the, that for which DCF took a child into custody. given the very generous safety net that we have in Massachusetts in comparison with other states. Not one case has been brought to my attention. So if you're out in the clinic and you're seeing one of these cases, I beg you to call the Office of the Child Advocate complaint line and give me the name of that case. Because I can assure you, if that's happened, we will ensure that that child is returned home and that whatever poverty issues are taken care of will be taken care of by our intervention.
So I told you this would be a provocative and lively conversation. You know, one of the, I neglected to mention this. I just said, Maria, or I noted that you're quoted in the Rappaport article. The quote is, Rappaport quotes Maria Mossaides, director of the State Office of the Child Advocate. Pull every kid is what she suspects DCF workers are being told after baby Bella was found. So then she, of course, Rappaport, you know, probably disagrees with you on this because she then writes or wrote, this is a 2016 New York article. This reactive tendency focuses on removing more poor children from poor families, a war on poverty versus a war on abuse. So, you know, again.
Let me correct, what she didn't quote was that
Okay.
we actually then collected data post baby Bella and discovered that the children were being taken into custody because of the opioid epidemic. So I went out and actually collected data, which of course Jill did not choose to quote me on, but there was data post baby Bella that the increase in removals were directly tied to the opioid crisis in 2014, 2015, and 2016.
So we'll have Jill Rappaport on the next panel, right?
Good.
All right, so Jenny, this is really you know, getting, you know, provocative, I think, at least, you know, for me. So, you know, relative to the conversation we had about who are we protecting? We're protecting children from abuse and neglect. Are we protecting children from the trauma of state? Because you talked about trauma, yes. Placement is incredibly traumatic. By the way, I got to recommend a book to you all, Invisible Child. Have you read it? By Pulitzer Prize winning book by Anne Elliott. Please. Pardon me?
Thumbs up back here.
You know, it's going on my syllabus for the course. I mean, it's so good, so good. You know, and in that book, she this reporter embedded herself with a family in New York, 8 children, and the state of New York was spending $400,000 a year on substitute care, on various forms of support for this family, which was the saga, quite candidly, is a saga of these children battling to get back together with their mom. So this is a very, very complicated issue. So again, who are we protecting children from? What do you think?
Name it. It's every system that exists. I mean, I think, excuse me, we end up seeing it. I think CFPG did a study, one of your reports on what happens to foster kids with education. I mean, you know, I think what we end up seeing is the effects of students not get, or not students, children not getting the support services, et cetera, in any system that they end up in. And I think, you know, we need to broaden that that protection piece. It's not necessarily just about removal or what happens in a care setting, and it's not about pitting child's interests against parents' interests either. We're not just protecting children from situations that, as Maria is outlining, you know, once they get into a system, what are we doing to support, and how do we create? I guess we need to change the way we even talk about families and kids. We start with a deficit model. We're not looking at strengths necessarily. Even talking about trauma, that has, you know, we are, I think, training people much more so in terms of trauma-informed practices in schools, in social work, et cetera. But we're still, I think, looking at at that with a deficit lens. And I think we need to turn this a little bit more into how do we take strengths and put supports in that actually will take those strengths as opposed to trying to find the right word, as opposed to just continuing to label. And that's a lot, I think, a lot of what we end up seeing. So
I think it's difficult because, part of the conversation obviously entails the quality of substitute care, which unfortunately is not good. So, the reality of people's lived experience, which relates to the question I'm about to ask you, Senna, is really, really important because we could talk about the benefits of, services, but we don't do a very good job of that, You look at the quality of care in our foster care system and group care, it becomes sort of the child welfare arm of the Cradle to Prison pipeline. So, that's part of the, I think, thinking really, carefully about supporting families in a way that is good for them and is going to be better protect all of us in public safety as well by keeping people out of care and minimizing state intervention is really, really important. So, Senna, this is your question. You spoke you spoke at length about some of the data. By the way, here's the thing about the data. We need more data. We have a lot of data. We need more, looking at these sort of intersectionalities of our children who are involved in multiple systems. And one of the issues that's really difficult is in the context, and I speak of this as a former juvenile court judge, the juvenile court system is a closed system. We could have a really robust debate, conversation about whether we should open the doors to close the juvenile sessions. I'm a big fan of that. I think we'd have the best of both worlds. And I think the Harmony Montgomery tragedy underlines that. If we're going to have a public debate about systemic reform, we should all be sharing the same information. You could open the doors and still have protections in place to protect confidentiality, access to collateral records, et cetera. I'm a voice in the wilderness on that issue. Maybe from my lips to the legislators' ears someday. But Senate, how are we going to ensure that the systems we create to respond to the needs of DCF involved parents and children are created by those who have lived expertise, not just for input, but as real partners in the design?
Yes. This is my thinking mute before I start talking. Can I just backtrack a little bit and just
Sure.
address something, Maria, you talk about poverty? I'll just give you just my example. I'm not an attorney. I used to work at Rosie's Place. So these are the women I worked with.
You just work with real people who are involved in systems.
Everybody works with real people
Yeah.
from a different perspective, right? So I've worked with the women who have been multi-generation involved with child welfare system. They're all in poverty. Mom, she's now grandma, had severe mental health needs. That's why it was involved. But not because of her mental health needs, but because she was in poverty, she didn't have the support to deal with her mental health needs. Her daughter was born. Her daughter has been in the foster care system until she aged out. She and her mom and daughter come to Rosie's Place. I know both of them. The daughter is now a mom. Mom has DCF in her child's life. It's an open case. She has her custody of her child, but it is like just being on probation. So yes, that I have legal custody, but anything I do is being overseen by the state. That is not for I'm going to guess for the most of you who are in the audience today, and many of us, it's a different reality to be the one that the state is looking at everything you do. And any mistake you do requires a state intervention because you are not qualified enough like the rest of us because of your poverty. So yes, I agree with you that nobody comes in and says you're poor, you're removed. But the fact is, poverty means you don't have the same supports. And when you have the supports, they come with legal strings attached of state supervision. And that's the same thing with mandated reporting. I am not, in my profession, I am not a mandated reporter. If I suspect a child is at risk, I have every right and every authority to call the DCF hotline. My friend who's a teacher is a mandated reporter. if anything happens to this child, the mandated reporter means if you did not report and something happened, you will lose your license, you will lose your livelihood, you will be fined, you could be criminally charged. My friend who's a social worker says a teenage mom came and told me, and this is what she does. As a middle-class mom, this is not how I would discipline my child. It was not hitting even, not even physical. It restricting, it was restricting something. I forget what it was, but it was like that. That doesn't. But as a teen mom, this is what she chose to do. I don't think this requires child welfare involvement, but I cannot lose my license and help everybody else. That is what we're talking about when we talk about punishing poverty, is that by being poor, you require the state and every one of us who is part of the state's intervention to oversee you and monitor you and decide if you meet our standards. The law doesn't say any of that, but that's how it plays out. And in a black mom I talked to, she literally, I tried to write her quote. What we really need, going back to your question, because I'm going to your question, what do we need? We need community-based services that we are not afraid to use. So when we have that conversation, we have to understand that's where people are coming from. And that's when we say, yes, there are severe tragedies. There are horrible things happening to children. How many of them could we prevent by saying, I can honestly say I need help and I'm not scared to ask for help. Not everybody. I'm not going to agree. There's some cases that you need removal, but I think for us to relook at the system and say, if this is what it means to be safe, we're not really keeping kids as safe as we should be. And I would say probably not, if they're still scared as grown-up parents of this happening to their own children. So what does that mean? I'm totally not looking at my notes at all. I'm looking at everything from my personal experience, where if you are a mom and a mom of color and you go advocate for yourself, you're an angry person. Angry, put in whatever adjective of a ethnic. I'm an Arab. I'm an angry Arab, angry Black mom. You're angry. You're uneducated. If you're emotional, you're being disrespectful. If you're not emotional enough, you don't have affect. We don't know how are we allowed to present ourselves and talk about our own children without being told you're not good enough. And we need our system, which is in my first lesson in undergrad policy class. The system is not a sentient being, but we all are. We need to know that when we look at these policies that look like they are race neutral, they are protective, that they are done by people that have, and that's where we come from. When we talk about, do we need to abolish this system or that? This is why when we say, if you have been involved, you're not less than. You have an expertise. I'm going to give you an example. I used to live in New York and I did, again, child welfare stuff in New York. I was actually doing domestic violence work, and the intersection of domestic violence and child welfare was a big part of it. So I came in from the domestic violence field. And in New York, the Administration for Children and Family Services, ACS, was the agency that everybody was scared of. There was a group of parents who organized. All of them were in the system, the Child Welfare Organizing Project. I'm dating myself. I think they have a different name now. It's been 2 decades. But that's what they did. They said, we are experts. The system is not going to take us seriously, but we are going to organize. We are seeing that in Massachusetts, early stages of families organizing on their own, without state support, without foundation support, without staffing support. And that's what we need, is all of us are getting paid to do this work. All of us are being paid to be experts in, or paying to be as tuition, to be experts in these fields. But if you have been in the system, you have to be seen as just on the same table as the decision maker. And I will put this out there. If our next child welfare agency head or our next secretary was someone who was in the system themselves as a child, that expertise is more than many of us are going to earn through years of professional expertise.
And that's a perfect note to end the panel on. Because I see Lissy's got the microphone. So this is Truth in Advertising. We promised that the concluding portion would be engaging for you. So this is your opportunity to pose any questions to any of the panelists.
You raise your hand.
Raise your hand if you've got a question or a comment. Well, actually, no question. We don't want, we don't want those long comments and we go, where's the question?
Hi, thank you guys so much for sharing your insights. My name is Gus. I'm a 1L. I used to be a special education teacher before coming to law school. I'm really interested in your vantage points. Jenny, you mentioned this, how your organization really works for the child. And might not be a question. I'm curious though on how you confront situations where a family, and when I think of family, like a parent's interests are in direct opposition to a child's. And I think Jenny, you alluded to this a bit of like they might have the same interest, but I can think of some situations where that's actually not true. And so how do you navigate situations where actually the interests are in opposition to each other?
So we are, as an agency, we're clear who we represent. Is that good? Okay. We're very clear who we represent, and that is the child. We are clear with the parent and we're clear with the child. And it is the child's expressed wishes. So you're right, especially in the world of education, there's a lot of times that could be in conflict, I guess is a word we can use here. But the reality is that the role we play becomes, helping everyone look at the end goal. And that is often, so for example, residential school, no child is going to immediately want to be in a residential school or outside of the home in any way. But there's a process in individual situations to get to, what would be helpful and how do we have that conversation? It is not, I would say it is rare that we end up needing to potentially withdraw because there is that conflict. Parents have the decision-making rights.
So before we have another question, but I just want to comment quickly. Before I was a judge, I was an attorney for 20 years and that's what we did, right? We represented children and young people and we worked in a multidisciplinary context. We had social workers on staff at the Youth Advocacy Project. And representing young people, as you know or will learn, is it's an art. We believe in client-directed advocacy, but it's not done robotically. So you have a counseling function as a lawyer, but the counseling function is derivative. It derives from the first obligation to be a zealous advocate. Once you have the trust of the client, you could have you have conversations, and you'd be surprised in many instances you could bridge those disagreements with parents as well. So it's usually works itself out in most situations.
Had to make sure that was on. Hi, I'm Will. I'm a recent college graduate. I'm also an intern on a documentary that is looking at the child welfare system in Massachusetts and nationally being produced for public television. It's my understanding that the documentary was not allowed to have a video crew here at the discussion today. And I was just curious, given the public importance of these issues, isn't this a topic that should be receiving greater public attention? And why restrict media coverage of these important issues?
So I'm going to take that question since I was engaged in this. I don't want to be recorded for this. Boston College has a policy of not having other recordings other than the recording we do. This entire program is being recorded. You are all welcome to watch it on the YouTube channel, Boston College's YouTube channel. It'll be put up, generally takes 1 to 2 days. And in that way, we ensure the entire program is recorded in its entirety. So we chose, BC has on occasion awarded special permission for outside recordings. We chose not to have that occur today. And that's the reason. The topic is vital. We all agree, and that's the reason we are having this program with esteemed panelists. So that's the reason.
Thank you. Any other questions? Drew.
Good afternoon. My name's Drew. I used to be a 1L.
Many
Yeah.
years ago.
Yeah, right here.
Another back row 1L.
Exactly, another back row BC person. My question was really for Maria. Maria, you sort of mentioned sort of in passing about the role of bad lawyering. In this, you use the phrase bad lawyering. And so I was just wondering about how you're putting the emphasis on inadequate lawyering juxtaposed with the $1.3 billion Department of Children and Families, who's the custodial agency of these children and who has nearly unfettered discretion in the decisions that they make about what they do for children and families. So I'm just wondering how you're weighing those two things and choosing to focus on bad lawyering rather than the decision-making of the department. That's a comment posed as a question.
Oh, I got that. And I want to really thank you for that,
My more.
for that question. I think that one of the things that I've been advocating, particularly in the child welfare area, is that every part of the system, and I mean for that, the legal services people who represent both the children and families, as well as the judges who hear these cases, right? And what I think that what we see, and there is very inadequate data, other than the data that we can pull out of DCF, which has limited structured data, that my expectation is, and I've been participating for the last year with a group of substance use disorder peer mentors. Every single one of those individuals has lost custody. And when I talk to them about their experience, and again, I don't want to, you pick these individual cases, you don't know whether they represent the full, what the real numbers mean, so I hesitate to use them. But what they described was that they felt that they had not been, number one, that they didn't understand what was going on, that they were not informed of what DCS was supposed to do for them. From my perspective, it's every single actor in the system needs to be doing their best to, number one, make sure that a child is not removed if they don't need to be removed. We're currently pulling some data, and we have to hand pull data. So that means reading every case that indicates that a lot of the children who come into custody, it's for a very limited period of time, so I need to do more. Really, that most of the children who come into custody after court hours, so that like after the courts are closed in the afternoon and through the weekends, and are coming in as a result of overdoses of parents. So it's a response to a 911 call. The EMTs show up, the police show up, the police call DCF and say, you need to take custody of these kids, right? And then hopefully we have a hearing no later than 72 hours. But what we know is the hearings aren't even occurring. For me as an attorney, the idea that the Commonwealth is holding custody of a child for a month, and that child has not been brought, that issue, before the court, right? So I am holding a child, frankly, unconstitutionally for 30 days, bothers me like hell. Okay, as a Commonwealth child advocate, because maybe that child would have been returned home, or we would have found a family member. So 57% of the kids who are in state custody are actually with kin today. And so I'm really concerned that the entire system, every single actor, is not doing what they can do that guarantees that right decisions are made, and that includes that families get the services that they need, right? And we recognize that in our current system, nobody wants to work in human services. So we have gaps in behavioral health services, we have gaps at hospitals, we have gaps in terms of the congregate care facilities. We are in a crisis that was there before the pandemic, but worse now. And so for me, it's not I said maybe bad lawyering, I don't know, but I've got a question. If really all of these cases have no validity, why isn't anyone objecting at the 72-hour hearing?
So I got to jump in here because we're gonna have time for 2 more questions, but I just have to say quickly, I love this conversation. It's one of the reasons why in 2005, the National Council of Juvenile Family Court Judges recommended that closed juvenile sessions be open to the public. And again, it's not either or, because of the complexity of the issues and the need for more resources and to address and to see the nuances of what actually goes on in practice. Question.
Hi, hello. My name is Stephanie Rodriguez Ruiz, and I'm a personal injury attorney, but I did work at the Children's Law Center as an educational attorney for a while, and I'm a Rappaport fellow.
Cool.
My question is really the question, Maria, that you posed to yourself. That was the very first question. I don't believe you answered it, which was whether the system should completely be abolished, if I can remember correctly, if that was the question, or revamped. And I'm interested to see what your answer is to that.
So I'm a
Or don't report or report.
No, I'm a systems design person, right? And so families are stuck in these multitude of systems. Since I've been the Commonwealth's Child Advocate now 8 years, what I've tried to do is to enhance the family serving systems. My goal is that a very small number of people over time will come to the attention of children and families with a much more discrete definition. What I know is, in order to get the Massachusetts legislature to agree to a change in the definition, the Office of the Child Advocate and/or a whole bunch of other people are going to need to produce data for the legislature to prove to them that we are not leaving children at risk. Because every time a child dies, and every time we have a case like Harmony or David Almond, you cannot have a conversation with the Massachusetts legislature. They are really clear that they are falling on the side of children. They have to get elected. And I say this with due respect to the legislators. So what I'm trying to do is to collect information and prove that if we provide the right levels of support, we're doing this with substance exposed newborns. We are several weeks away from some major changes that will immediately reduce a whole bunch of cases from coming to DCF. I can only do that when I collect data that says to the legislature, you are not placing children at risk. So our emphasis at the OCA around data, qualitative analysis of cases, is because that's the only way we can prove or at least advocate on behalf of children and families. So I am not willing to eliminate child welfare because of the cases that I see all the time. There are children who need to be protected. Now, we need to do a better job when they're in state custody, and I'm not going to deny that. But I don't think that we are at a point that we can say that the cases of sexual abuse, that the cases of physical abuse, and those cases are actually, Judge Blitzman could say, the easiest cases to deal with. It's the neglect cases that are the hard cases, and it's the neglect data that we need to do a better job with so that we can prove that there are alternative systems that will provide the stability, will reduce the trauma both to the parents and the children. But what I've also said to key members of the legislature, we are looking at providing services for a much longer period of time than the 18 months that the current statute requires for DCF.
All right, we have time for one final question, if anybody has one.
Kate.
Wait.
Kate, because you haven't asked a question, right?
I haven't, and I'm gonna admit, sorry, I'm gonna admit this is probably more of a comment than a question. So I'll follow in Drew's illustrious footsteps in that. My name's Kate Niemans. I work with a project called the Mental Health Legal Advisors Committee in our Family Law Project. I think going back to the question of abolition and reform, you know, Maria, I just point out sort of your own comment about multi-generational trauma. If we are seeing a system that is producing a grandmother who's been involved with the child welfare system, a mother who's been involved with the child welfare system, and then a child involved with the child welfare system, I guess I would just suggest we have to look at what that system is actually doing to families and who is getting pulled into that. We're clearly failing. We're failing all of those families, and we're failing them at multiple generations, one after the other. And that says to me, when we've been trying to reform the system for as many decades as we have been trying to reform the system, that maybe we've reached the end of looking at this version of supporting children and families. And I would strongly recommend that this would be a way in which we approach this work, if we're thinking about it from that viewpoint.
So that comment is actually, we're out of time, but, you know, this has been, I told you this would be a provocative conversation. Our role here was to provoke, but perhaps not resolve.
And on that note, I want to say it was in fact provocative and respectful. And the Rappaport Center, as the Honorable Jay Blitzman said at the beginning, we are trying to inform the public. We are trying to illuminate issues. We are trying to show different perspectives. I think we successfully achieved those goals, and we did so with an incredibly esteemed group of panelists and moderators. So thank you, thank you. Thank you for all the work you do on behalf of the children and families in the Commonwealth. Thank you so much.